Hi, everybody. Thank you all for joining us today. My name is Alex Campbell. I'm with the DAYL Judiciary Committee. We are here in our second part of our three-part series on getting to know the courts. Before we get started, the DAYL would like to take a second to thank all of our sponsors who made this event possible today. We have our platinum sponsors, Ackerman, Bell Nunnally, Burke Bogdanowitz, Cobb Martinez Woodward, Dorsey, Ferguson Braswell Frazier Kubasta, Greenberg Trarick, Hartline Barger, Kane Russell Coleman Logan, Castle Law, Lynn Pinker Hurst and Schwegman, Lyons and Simmons, Platt Shima Richmond, Ryan Law Partners, and then our gold sponsors, Aiken, Gump, Strauss, Power, and Feld, Carrington, Coleman, Sloman, and Blumenthal, Reese Marcados, Van Way, Presby, and Williams. Now, today I've been joined by two of our distinguished justices from the 5th District Court of Appeals, Justice Aaron Nowell and Justice Bill Peterson. Justice Nowell was elected to serve on the Court of Appeals in 2018. Before serving on the bench, she practiced for 15 years, litigating large-scale mass torts, as well as participating in the defense of several class action defendants in federal court. Justice Peterson took his position on the Court of Appeals in January 2019. His prior experience includes working for the Collin County District Attorney's Office, where he tried over 60 jury trials to verdict. Justice Peterson also worked in private practice before taking the bench, where he handled both criminal and civil litigation matters. We thank both of you guys for joining us today, and I could obviously go on for hours talking about your impressive accolades, but everyone came here and wanted to hear from you all, so I know we have a lot to cover, and let's get into it. The first thing, I know I provided a very brief background for both of your professional careers, but if you all could both kind of shed a little light on what led to you all serving on the bench. Were there any experiences in your career that were particularly influential or guiding on your path to serving? Justice Peterson, I'll let you go first, and Justice Nowell, if you have anything to add, let us know.
Okay, well, thank you. First of all, I want to thank DIYL and all the sponsors for allowing us to communicate with everybody this way. We hope that this increases everybody's familiarity and understanding with how the 5th Court of Appeals anyway works. I had a broad variety of experiences in private practice. I had an unfair advantage. My dad's a lawyer in Nacogdoches, so when I would take a new kind of challenge on, he was really it's like I had bumpers when I was bowling. You know, he would keep me out of the gutter too much. So I was lucky that way. But I really enjoyed, as was previously referred to, I really enjoyed trying cases in the DA's office. It's impossible to get sued by the state of Texas for losing a misdemeanor trial. So it's kind of a malpractice-free zone. And if somebody gets away with shoplifting, well, the sun's gonna still rise in the morning. So that was a very good experience for me. What got me involved, what made me want to run for office was the 2016 election. It got me much more interested in political involvement. And I think I also thought, and I'm not the only one, of course, that it would create opportunities one way or the other. I certainly encourage everybody to be involved in any political interests or political organization or service organizations or the bar association. Being involved in lawyer associated groups is good. You meet people that you can learn from and talk to about your cases. Most fogies like me really view it as a compliment when somebody asks for our advice. You know, what do you think about this or that? And we all remember fondly when we were first starting out, and what an exciting time in somebody's legal career that is and can be. So that's all I really have.
Okay, I first and foremost am not going to take on the mantle of a fogey. I refuse.
Just me.
I'm still a youngin. As you can tell, I am from the South. I'm actually originally from North Carolina. Law school is what brought me to Texas. I wanted to do trial work. That was mainly my focus of how I got into doing mass torts and working with plaintiffs. And it was actually working with plaintiffs that is what got me to the bench more so than anything. I often had to deal with cases where we had verdicts, we had, we'd done a lot for our clients, and defendants would either not settle, would push back because, quote unquote, I'll just take it to the Court of Appeals and they'll overturn your verdict. And for a long time, that was the belief of how our Court of Appeals worked. And so I realized that, hey, you know what? I might be able to help my clients more by fighting the fight to diversify the thought on our Court of Appeals. And so that was actually what led me to running for the bench. So I guess one of the things I would say, good advice as you're moving forward, pay attention to your gut, pay attention to what moves you to practice. And I think opportunities will present themselves that will allow you to both do your work, but also get involved in the type of service that you want to be to the legal community, to the community in general, et cetera. I think, DAYL is a great example of that because you all have so many different committees. And so people not only can network and get to know each other and grow as lawyers, but they can also do the type of service that really calls them to what we're doing. So it's, again, not work if you're enjoying what you're doing.
Excellent. Yeah, obviously we're here, so I think we couldn't agree more with that sentiment. Moving on to the actual Court of Appeals and what you all do on a day in, day out basis. Before we get into some of the finer details, obviously we're the Association of Young Lawyers. A lot of us are relatively new to the field of law, especially compared to the fogies in the panel.
Fogey.
Only one. There's only one.
Fogey.
Just one in the panel.
Singular fogey.
Well, but on that note, Justice Peterson, since some of us, especially with COVID going on, have not had the same sort of exposure to courts as in years past, or with your experience as working in the district attorney's office, can you kind of explain to us what the Court of Appeals jurisdiction is and a little more insight on what matters you all handle, whether it be appeals, writs, or any other kind of topics?
Sure, happy to. Well, the 5th District Court of Appeals supervises, for lack of a better word, the trial courts in 6 counties: Grayson, Collin, Dallas, Rockwall, Kaufman, and Hunt counties. And when your murder trial or your personal injury lawsuit or your will contest or et cetera, your child termination case, whenever that's over, we grade the trial judge's paper. We have only a very limited role in reviewing factual determinations by either a trial court judge or a jury. We're really just evaluating the things that the trial judge did. It all begins with Texas Rule of Appellate Procedure 33.1. You got to let the trial judge know they're making a mistake if you're going to complain about it later. And that's largely what we're doing. We have a very broad, we have to all be generalists when we get here, because I had a pretty broad and varied practice. Other members of the court have had a very specific practice, all of which is fine. I learn a bunch from my colleagues all the time. I just got done last spring being on a panel with Justice Now, and I learned a lot from her. And I hope that I've helped her understand something at some point during our service. And we don't really hear if you're talking about writs, if you're talking about a writ of mandamus or an extraordinary writ, those can be returnable to us. If you're talking about like a writ of habeas corpus after a criminal conviction in state court, generally those skip us. Those are usually returnable to the Court of Criminal Appeals, and they handle all of that. But we handle just everything else. If you go from JP court to county court at law and an eviction, you can come to us. And we are the last court of right. After us, you're just hoping somebody's interested. The Court of Criminal Appeals in a criminal case, or the Supreme Court in a civil case, or the United States Supreme Court. But we're the last place you absolutely get to be heard. So.
Good. Well, and so Justice Now, how many appellate justices serve on the Fifth Court of Appeals? How many of you guys are there?
So there are actually 13 of us. We have Chief Justice Burns and then 12 associate justices. We sit in panels of 3. As Justice Peterson said, we were on a panel together, and we do that in rotations. A lot of people don't really understand how that works because I don't know how clear it is, but we sit in rotations that are about 9-week rotations. Those may be oral argument cases. They might be no oral argument cases, but we basically have a subset of cases that we hear in those panels of 3. People often try to figure out, how do you decide who's presiding? And quite frankly, it's a roll of the dice. Whoever is presiding, they preside for the entire panel. If you talk about what case the person is going to take, we have a really odd kind of pick process to make sure that the work is evenly distributed. But one of the interesting things about our court that's different than other courts is we don't know when we step into oral argument whose case is going to be what. We don't know who's taken what case. We don't know what's assigned there. So I think we really enjoy that because, as Bill said, it gives us the opportunity to, we will generally talk before oral argument and then after oral argument, and to learn from each other and to really think through it. So you don't have one judge who's already kind of made a decision about what they want to do with this case before you come in. You've got 3 judges coming together and talking through issues. And things change from oral argument, from panel discussion, from that type of thing. So we sit in those panels of 3, and then that changes every 9 weeks or so. So we normally have 4 rotations a year of different panels. And then our writ panels are completely different. Those are separate groupings of 3 that hear writs of mandamus on a monthly basis.
So none of the attorneys in the audience today have to worry about walking into the courtroom and getting ambushed by 13 appellate justices at once, right?
That is only if they have requested en banc and they know that it's coming. So you should never be ambushed with 13 of us. If you didn't know you were going to 13, that's a whole problem. Yeah, actually, when the cases are set for hearing oral argument, they will send you a letter, and you will even know which justices will be on your panel. We try to make it transparent in that way, so you shouldn't feel ambushed in any way. You should know exactly who is hearing your case, and that type of thing. So.
And you don't have a specialist that focuses on torts or contracts or any sort of specific area of law. It's kind of like what you said. You get to learn something new every day, right?
Yeah, I mean, Justice Peterson said, I very much enjoy being on panels with former criminal practitioners because, in fact, I was very lucky. My first panel, I was with Justice Lana Myers, who was a criminal court judge for years before she was ever on the Court of Appeals, and has been on the Court of Appeals for years as well. I'm not trying to date her, but because I didn't have a background in criminal law, it was so enlightening to be able to talk through these issues with her because she had that background, and then I have a civil background, so I've been able to help my other colleagues who don't have certain civil background. We have labor colleagues who have labor employment. We have Justice Garcia now who has her family law background. So it's really nice that we do communicate with each other and we can learn from each other, and people have different specialties, and it's really helpful.
Absolutely, right. Moving on to the finer nuts and bolts of appellate practice. Even though we're a younger audience and some of us probably haven't worked on an appeal before, I'm sure everyone remembers writing their appellate brief for law school and then the ensuing moot court competition that came afterwards. So I think people are somewhat familiar with the process at least. Justice Peterson, if you can kind of elaborate on that though, explain how appellate court weighs an appellate brief compared to that of an oral argument. Does one take precedent or priority over another? Do you look at them at 50-50, or what's that process like?
Well, it's easily not at least 90-10 the brief. In the advice I give people about briefing is you should take your brief when you think it's ready into a lawyer's office who isn't familiar with your case. Hand them the brief and say, please read my brief and let me know if you understand what I'm saying. And if they're a licensed attorney and know anything about the law, that should be all they need. If you oral argument is, in my opinion, is to help the appellate court understand your arguments, answer any questions. I mean, you can wring concessions out of people that they may or may not should make at oral argument. And then, you make a credibility determination when you're confronted by an appellate court judge. Well, isn't this true? And if it's true, you should probably agree that it's true. If you deny that it's, then that can affect your credibility going forward. But oral argument is really just to help us and but if you should not rely on oral argument, and you'd never know whether you're going to get oral argument or not. Probably half of our cases do not get oral argument. So you cannot rely upon those. If you're waiting to to make your point in closing argument at oral argument, you may never get the opportunity. So you need to make sure that your brief is very clear. What I have found, it is entirely appropriate for lawyers in the course of seeking to zealously represent their clients to really grind over how you say things and the cases you cite, and that you're getting the law right. And all of that is necessary and appropriate. But you should also understand that this is none of our first rodeo. And let us know what the legal question, what the legal issue is, and then help us determine how we are to come to that decision. It is not helpful to repeat your jury argument, for example. If you talk about, the prosecution's witnesses told contradictory stories there, and you draw some fine distinctions. Well, that's over now. That's not what we're here to do. We're here to answer legal questions, and we are unlikely to be, to burst into tears because of your emotional argument. That may feel better, and your client may like that, but that probably isn't going to make you effective at getting relief in the Court of Appeals. It's a little more. It's as much math problem as it is, art.
So, Justice Now, do you have anything to add? I mean, would you agree with that?
I would agree with that wholeheartedly. I think that a lot of things that I don't know that I even realized just as a practitioner is, I know and non-practicing, non-lawyers especially, they have this belief that the Court of Appeals is a do-over. Oh, we're worried about it. They're just going to appeal that case. Well, what's really different in our court is we have what they call standards of review. So we can only look at error that's raised under a standard of review. So for instance, whether a piece of evidence came in, that's an abuse of discretion standard. And what that means is, unless the judge just basically flouted the law and said, the law says this comes in, but I'm not letting it in, we're pretty much going to allow the court, the trial judge, to have domain over their courtroom. So it's very hard for you to come back to us and say that piece of evidence should have come in, unless, if it was a judgment call for the court. We don't make judgment calls on their judgment call. I don't get to say, oh, well, I would have done that differently, so I'm gonna change that outcome. Now, there's legal sufficiency and factual sufficiency, looking at whether there was enough factual evidence, whether there was, legally speaking, they met the legal standards of the evidence before the court, where we're looking at, I still wouldn't call that a do-over, because again, there's a lot of deference to what happened in the trial court. So I do think that people need to understand that what you're bringing to us is under a specific set of review. It's not just a do-over. And I know one question people always ask is, what do you want to see in a brief? Absolutely, what has to be there. And we all have pet peeves, whether we like our footnote, footnotes in the, whether we like it, citations to the footnotes or citations to the record. That's all going to be individual. But I will tell you, I don't know a judge that will not say they absolutely want to see in the brief a clear statement of what you want us to do. It is nerve-wracking to get 3 pages into a brief and not know what it is you are asking us as a court to do. So if I can't read your, summary of the argument, if I can't read your table of contents and know these are the issues that you're raising, this is what you want me to do, then it puts you in a really difficult position, because you don't want me reading the facts with not an eye to what it is you want me to do. And you certainly don't want your judges being frustrated and having to reread what you've written to try to understand just what you're asking the court to do. And so what I will say is I absolutely need to see a statement of what you want me to do. What are you asking the court? What are the issues? Not a long drawn out 3-paragraph synopsis of your argument that I'm trying to parse out, but just a simple statement of what you want me to do.
Excellent. I think that, it's easy on us and it's easy on you to avoid having to wait till the 25th page or the last page of the brief to figure out what the end game is there.
And certainly not until oral argument, because that happens every once in a while too. We'll get to oral argument and like, oh, that's rare. It's almost as rare as I will tell you, I've had at least one oral argument where there were just so many different, like we even had charts that they provided. There were just so many different interconnections, and it wasn't until they had oral argument and were able to say it to us, like in how it was broken down, that it really made sense. And that happens every once in a while because of really complicated legal issues, but that should be a complete rarity. That should be like 0.005% of the time.
Perfect. Justice Peterson, I think Justice now made it abundantly clear what has to be in a brief. On the flip side of that, is there anything that you see when you're reading through a brief that just drives you crazy, or you look at it and you think, man, that really hinders the credibility of the author? Just something that really you don't want to put in there.
Well, one thing to remember is credibility matters. If you cite a case and I go look at that case and it doesn't really say what you're claiming it said, you're in trouble. I'm going to be skeptical of everything else you say. Again, also, likewise, if you cite to the record and I go to the record, or one of the staff attorneys goes to the record and says, yeah, that really isn't a fair reading of the record, you're going to pay a price. That doesn't mean you're going to lose, but it isn't going to help anything. And if you think this is the only appeal you'll ever file in the Fifth Court of Appeals, okay, I guess you can roll the dice. But chances are, if you do this once, you might do it a second time. And if we remember you, you don't want us to remember you as the lawyer who went too far. I mean, the most credible thing you can do is concede things that you should concede. You want us to view you as an honest broker who's just fairly making a legal argument. And you understand what you think the trial judge did wrong, how we are supposed to evaluate that wrong, and a very clear statement, as Justice Now very accurately said, of what you want us to do about it. Appellate review involves a standard of review, and then let's say we find that there is some error. How harmful is that error? If 9,000 pages of reports come in and one of them shouldn't have come in, what are the chances that the other that was so important that we have to reverse? Probably the other 8,999 pages are enough. We're probably not going to need to reverse that trial. So, just remember that we may remember your name, and you want it to be for a good reason. We had oral argument a little over a year ago, and one of the lawyers at the beginning of his oral argument stood up and said, may it please the court, I have something to tell you. My brief was predicated on an argument that the Supreme Court in recent weeks took the air out of. Because of the Supreme Court's holding, my brief is no longer good law, and I just want to come clean and tell everybody that. That so impressed the justices that they put they praised that lawyer in a footnote in the opinion, and send an email to the rest of us saying, hey, this lawyer did a really good thing and I want to brag on this lawyer. You'd rather be there than the other direction. So
Absolutely. Absolutely.
Can I add one thing that's actually different? I agree wholeheartedly with everything that Justice Peterson said. One of the don'ts, kind of going with something he said in the beginning, where emotion doesn't work in oral argument, it also doesn't work in your brief. I will tell you, it is frustrating to me, the number of adjectives and adverbs that we have in our argument. I know that you all have probably been fighting for a year and a half about these issues, but vitriol and hyperbole and lots, what I actually tell people, go through your brief. If you have, and take out every word that ends in ly, clearly, unconditionally, certainly, absolutely. You don't need any of those words, unless they're in quotes from a citation, because that is frustrating to us. And that distracts from the meat of your argument, because as we keep saying, we're looking at legal standards. We're not dealing with emotion. So I don't want to read the vitriol back and forth. And that does affect your credibility to me when whether you're arguing or not, if that's in your brief. So I would say don't. That's a huge don't. Keep the emotion out of it.
Another thing I'd like to briefly add, if I could, is that the other side, they're just the worst. You just can't, any of that stuff. First of all, we don't care. We are uninterested in the soap opera you've been having with your opposing counsel. And look, I've dealt with very difficult opposing counsel before. I've dealt with opposing counsel that I was worried I was missing something because they were being so nice. And that's part of the challenge of being a professional and a grown-up. We're uninterested in lawyer drama. We're interested in the parties and how and what is the law. And if you're thinking, well, I want to point out all the ways that the other side didn't shoot straight with the trial judge, or they messed us around on this or that, you are burning oxygen. You're the architect of your argument. You get to decide what you're going to use these precious pages and this precious time in oral argument. If you get oral argument, don't waste it. Talk about things that are consequential to your client.
I think you guys are doing a good job establishing this theme of what's in a brief and what needs to be there and not there. But you also kind of referenced that there's this very high standard sometimes you have to meet to show that there's an abuse of discretion. Would you guys say that there's some sort of strategy or tact to pointing out any sort of errors that may have occurred, but doing it in a way where doesn't sound like you're just trashing either the court or the opponent? Is there a method to that madness, or is it just good lawyering?
Do you want to take this one?
Sure. The truth be told, unfortunately, unless it's legal based, playing fast and loose with the trial judge, again, unless it's legal based, that can't really have an effect on us. That's not going to get to error. So an example of a time that you do need to address that. Let's say you know that your trial judge based their ruling on this subset of cases, and the attorney has fed the judge this subset of cases, but you know that those cases that there are legal issues with that representation. Now, the way that you would address that would be you would direct us to the record where they discussed it, and then you would distinguish what they're saying about that law that the judge relied on and what the law actually says. And then part of your argument would be it was an abuse of discretion because the judge wasn't following the law. They were following the law as presented to them, and here's why this is different. So the only ways that again, it's just not important to us unless there's a deadline issue or something like that, where did you meet the deadline and they did something that kept you from meeting the deadline. You know, it is so law-based with us. And our judges, we give our trial judges a lot of deference to make those determinations, because again, we're not seeing the back and forth in the court. I bet they see it more than we do. So that's who you rely on to parse that out. We're just not those people.
Something I would say is, believe me, we're familiar with all these judges. We only have 6 counties, and that's a lot. And ours is the largest the most humans are served by our appellate court than any other appellate court, intermediate appellate court in the state. We have 13 justices. None of the others have more than 9. But we're basically familiar with these judges, and some of them we think very highly of. Some of them we're not as impressed by. Some of them we are personally quite close to. Some of them we personally don't, may or may not be as close with. But you can't possibly know any of that. You can't possibly know who we really are friendly with, but you can't possibly know any of that. So you have to assume that we think very highly of all of the trial court judges. One, the standards of review generally reflect broad deference, as Justice Now so accurately described. But also remember, you don't know who was in my wedding. You don't know who I've been on vacation with or something. There are there are times when judges gather socially, and so all that said, you should behave and communicate with, and you also something about how the court operates. You don't know what judges are going to hear that appeal until you get the letter saying we either have oral argument with these judges or it's going to be submitted without oral argument with these judges. So you want to be careful because you don't know who you're going to get. So that's that. This is part of our consistent suggestion that take the personality and the drama out of it, because you don't know, you cannot possibly predict how your what you think is super funny or super pithy or really zinger, that could go over badly. So just keep as much of that out of it as you can.
Great. So we've got a question from the audience, and it harps on a point you all have reinforced today, is that oral argument's not a sure thing. There's no lock or guarantee you're going to get before a panel and be able to voice your case. Someone was asking, is there any suggestions on how to persuasively request that oral argument in your brief? Or is there anything you guys look at particularly that you think warrants an oral argument more so than another matter?
Are you okay if I go? And then Bill can. What I will tell you is one of the things that you have to know about our court is we actually grant oral argument more than pretty much any other court in the state of Texas. It's one of the questions I think we had talked about when we were prepping for this was, do we interact with the other courts of appeals? And we do. We all talk with each other. But the internal workings of the courts, even in Houston, where the 1st and the 14th overlap, they handle things completely differently. But in having discussions with them, they talked about how many oral arguments they have versus us, and we probably do, 3 times as many, if not more, depending on the court. So we're very open to it. I think we have a lot of justices that just feel like, unless it's just an issue that it can't help us at all, if both parties especially have requested oral argument, more likely than not, we're going to grant it for you. If it's a single issue case and one party has asked for oral argument and the other party has said that you don't need to, that's still a hard one for us, depending on what it is. But we think about that parties, and I will tell you, we think about this when we're granting it. Parties have to pay for their attorneys to prepare for and come in for oral argument. So if we're looking at a one issue case and one party has requested it, but the other party hasn't, we think about that when we're looking at it. What I will say is, actually, if it's something that you believe, if you've got a 7-issue case and you want to argue your case, it's very unlikely we're going to say, no, you can't come argue your case. It's going to be a big deal. But Sometimes people just put oral argument requested. Sometimes people put a statement regarding oral argument. And I would say, if you really want oral argument, you need to make that statement. And the statement shouldn't just be, it will help the judge, it will help the justices. That's a blanket statement. I understand that. Tell me why. There are intricacies in this type of law. There's a jurisdiction split on this. There are facts in this case that deal with different entities, and we think it will be easier to discuss with the court. We expect the court will have questions about certain issues. So tell me why, not just we think it will assist the court. If you really want it and you're worried that we won't grant it for you, you need to be very specific. On the opposite side, if you don't want oral argument, tell us specifically. This is a one-issue case. This court has decided this issue 16 times in the last 2 years. You can say those things to us. We're not requesting oral argument. The briefs are sufficient. This court has decided the same issue repeatedly. There's standard case law. We don't think it's necessary. That's going to also turn us. So we do read those and make that determination.
I'll also add that if you say, I'm a new lawyer and have never had oral argument, and I think it would be really cool to have oral argument, I know that Justice Nowell and I both would look favorably upon that request. That's a great thing to say.
Oh, and also sometimes people are trying to get certified, like for Texas Board of Specialization. If you say, I need oral argument to finish my specialization, we will grant you oral argument for that. We're perfectly happy to do that.
Actually, that's really interesting. I might have to try that next time if I want to hang out with the two of you again.
There are easier ways, but okay.
Well, as long as the client's okay with it, I suppose.
Right.
We were talking about the brief earlier, and you guys emphasized how important it is that it's heavily law-driven and based on the law. I think that's where a lot of the young attorneys can provide value to a senior attorney working on appeal is doing the research and looking up the case law that supports your position. But personally, I know I've come across times before where I'll get hesitant doing my research and finding a case from the Court of Appeals, either down in Houston or Texarkana, somewhere not within the Fifth Court of Appeals. And I'm not sure how heavily, that'll weigh in on your decision, especially if your court might have come up with a different opinion. So how do you all look at relying on cases that are coming from a different Court of Appeals, or even more so, if I find nothing scares me more than not reported or not published in opinion, what weight do those have?
Well, for my part, if you're aware of an appellate court decision that is relevant to the legal issue you're wanting that we need to decide, I'd certainly rather know about it than not. For my part, whether like in criminal cases, for example, non-published opinions are supposed to have no precedential value. But I will tell you, if the Fifth Court of Appeals has decided a criminal issue on a prior panel opinion, whether it's published or not, I'm going to need a real good reason not to follow that. And other courts of appeals, the short answer is there's no way you can know. There's no way you can know whether we're going to think that's persuasive or not. Of course, we don't have to follow it, but those are smart folks over there too, who are just like us, just lawyers trying to get to the right answer. So I would err on the side certainly of citing all the relevant authority you need to, or that you can, or that you think will be helpful for us making that decision. And as far as whether it's published or non-published or all those things, those are certainly noted in the citation, and we're familiar with that. This isn't our first rodeo, so go ahead and give that to us. And if you have a reason why we shouldn't follow it, make that argument. If you think we should, explain to us why we should. Those are judgments that advocates make, but I prefer more disclosure than less.
I don't have anything to add.
Great. Well, now it's helpful if there are a lot of cases that support your position, precedent, whether it be from your court, a different Court of Appeals, or the Supreme Court. But is there any different consideration given on a matter of first impression? I don't know how often you all get a matter of first impression these days, but But is your approach any different? Does the Court of Appeals approach those issues differently? And how do you guys handle that?
What I would say is, if you're saying, I think there's a difference between a matter of first impression that we don't think anyone has addressed, or a matter of first impression for the Dallas court.
That's a great
so you definitely need to make that. If it's a matter of first impression that no one has addressed, obviously we are looking at any case law that's close. We're looking at what the Supreme Court has done and whether this is in keeping with that. So that's when it starts to get interesting, because we may look at what the language was in the statute, and then we get into statute interpretation and things like that. So I think that's more where we deal with matters of first impression. There might be a new statute, or there might be a change in the statute, or just a new angle on something that's been hit before. So I will tell you, what we try to do is we look at what's available out there. For if it's a matter of first impression in Texas, we're then looking to see what's close to it, what's been done in keeping with that angle. But of course, that does open it up for outside jurisdiction. What have they done in the federal court? That's often we get guidance that way too. If it's a matter of first impression just for Dallas, then that is, again, we're talking about persuasive authority. What other jurisdictions have done are important, and I'm not going to, not to sugarcoat it, but we look at what these jurisdictions are. We know kind of how the case law goes there. So if you look, a lot of our case law looks a lot like Austin, looks a lot like Houston. We're a bigger city. We deal with, these types of things. So if Austin and Houston, generally speaking, have gone one way, and then Eastland and Waco have gone another direction, we're going to look at kind of how our cases are and what they're doing versus what we've generally done. That doesn't mean that we might not side with the Waco Eastland subset of cases, because that seems to be that reasoning seems to be what we've done in the past. So what I would say is try to understand kind of the reasoning behind the type of ruling that you're looking for, and check and see what that legal reasoning has been in similar types of issues, because I think that's kind of how we try to work through it.
I have nothing to add to that.
It sounds like I need to start doing more than just going to the head notes and looking for one that supports my position. You got to wade into those facts a little bit, right? So, we've been talking about the brief and everything. Can you guys explain what the concept of a letter brief is? When are they appropriate? How is it different from a traditional appellate brief? When do you look for things like that?
Well, an appellate brief is the initial, both the appellant's brief, the appellee's brief, and any reply brief are generally governed by the requirements of Texas Rule of Appellate Procedure 38. You got to have the identity of the parties and their counsel, and this table of contents, and the statement of the case, and statement of facts, and all those they're very specific requirements. A letter brief is when a brief isn't due, but you really want to tell us about something, and it's just an effective way to communicate with the court. I rarely have any problem with somebody filing a letter brief. An example, very, very appropriate times when I've seen letter briefs include, but are not limited to, the Supreme Court just came out with a case that affects your appeal. File a letter brief. Let us know about it. It's just put on your letterhead. It's not formal. It's, hey, court, this decision was made and it affects this matter in this way or that way. Or after oral argument, if we talked about some issue, and especially if one of the justices requested a letter brief, or if you, and again, this is going to be a judgment call, whether you think we want it or need it or not, but you may submit something and say, this issue came up and these cases are, or this issue, or this, this part of the record, or whatever it is. Now, again, you're confined to the arguments that were raised in the appellant's brief and the appellee's brief. You can't, if you cite it, if there's a new stuff, you can't raise a new issue in a reply brief, for example. But so there are limitations about all of that. But generally, you'll know if you think if a letter brief is appropriate or if we request one. And I don't have a lot of objection to them. Again, we have a whole bunch of cases, as Justice Now explained. We do more oral argument than any other court, and we're busy. You know, we have a lot of cases going. So be judicious about how long they are. But I find them to be, when they're used effectively, they're effective, I guess.
And I just want to add, and more so just reiterate, based upon someone had asked a question about the substance and the style and format, and I answered it. I typed the answer on the Q&A, but I did want to reiterate, we don't have a preference for format. I think Justice Peterson said that, you know, put it in a letter form on your letterhead. This is not some kind of extensive thing, but I would say the biggest issue is, if we've requested it, only address the issue that we've requested. And that's not even, don't raise new arguments. Don't re-argue your case in a letter brief. You don't use that as an opportunity to write another reply brief. If I got a 20-page letter brief that addressed my issue that I asked in 2 pages and then had 18 more pages of re-argument, I would be so mad. But you know, if there's a new case that came out or you want to address this issue, just address that issue. You can end with a paragraph of, you know, in addition to the other reasons raised in oral argument, we request the court do X. That's fine. But this is not a request for you to write another reply brief. So please limit it to those issues. Limit it to the new case or the one question or a new citation to the record or whatever. But don't use it as a way to go off script.
Oh, great.
I agree with all of that.
Perfect. We're going to start running out of time here in a minute, so I'm going to let the audience know if you all have any questions. There is a Q&A function or a chat function. I want to make sure if there's any points that they haven't addressed so far, which has been phenomenal, we get those in. And right now, I want to see, like I said, I can go talking for days about this stuff, but if Justice Peterson or Justice Now, if you guys have any parting words or last piece of advices you want to give that we might not have covered today, let's share that now, and we'll let the audience have any questions if they want to get those in.
I will say, just kind of looking at some of the chats and some of the things we talked about, I will say one of the things that I think does translate from the trial court is get to know our clerks, get to know our court coordinators. Someone is asking, what's the best way to ask questions if you're a new appellate practitioner? Call the clerk. How should you contact the court in the midst of appeals? Call the clerk. Our clerk's office is amazing. They work very hard. They try to be very responsive. So if you have questions, call the clerk. If they don't have an answer, they will come to us and ask it. Don't be shy about that. It's better to ask the question and know what you're doing than not. So just like the trial court, you want to know the court coordinator, you want to know the court reporter. For ours, you want to know our clerks. You want to know our clerk's office, and they are wonderful and available to you.
What I would probably add is somebody has done what you're trying to accomplish. Somebody has done it. You're already involved in an organization, the Dallas Association of Young Lawyers. You wouldn't be hearing this old fogey blather. So, but take advantage of those opportunities. If you're active in the Dallas County Bar Association or the Collin County Bar Association or whatever bar association is, or going to CLEs and meet lawyers and ask them questions, and there's somebody has heard this before, and if you can explain your issue to a lawyer who's not involved in it and has no real background, if they understood you in under 5 minutes, then probably we're going to understand you. But if after 5 minutes they go, well, what do you want? What are you talking about? What are you even complaining about? Like we talked about earlier, that can be a problem. But this is a hard thing. Being a lawyer is hard. Litigation is hard. It's a complicated thing, and there's a bunch of traps for the unwary. And so, reach out to people and ask for help because you need it.
Well put, well put. And I just want to make an announcement before we start losing people that you are getting 1 hour of CLE credit for today for joining us. And the course number is in the chat box provided for you there. So make sure you write that down before we leave. I think we got one last question that we'll finish on, and then I'll let you guys go because it sounds like you guys have a lot of cases to look over. But the question here is, what are your top tips for a lawyer's first oral argument before the appellate court?
Eric?
Okay. I think I'm probably reiterating what Bill said, but practice, 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 practice. Give your oral argument to different people, both people who know nothing about your case and people who have read and can understand the types of questions that you're going to get. What we don't want in the oral argument is for you to stand up and basically reread your brief. We start our oral arguments by saying to you, we've read your brief. So what you need to be prepared to do is to come in, hit your high points, talk about why you win, and be prepared to answer any questions that we have to you. So that's top tip number one. Top tip number two, know when to be quiet. And unfortunately, that is the hardest to learn. Some of the best oral argument practitioners will take 10 minutes of their time. They will reiterate their points. They will answer our questions. They will see that we have no more questions. We are where we are. And they will kindly sit down and leave 10 minutes on the clock. You can do that and still win your oral argument because, again, the point is to make your best points, answer our questions, respond to the other side, and sit down. Those are my tips.
Yeah, I couldn't agree with both of those more. Another thing I would suggest is relax. I mean, you know what you know. And if you get asked a question and you don't know, the best answer is, I don't know. Can I submit a letter brief on that? Can I follow up? I just don't know. I would rather hear you honestly say, I don't know. And then, well, gosh, why didn't they know that? Well, there's a bunch of stuff I don't know. That's why I'm asking, right? So it must be possible not to know it. Just say you don't know, and I'm not sure, and I can get back with you on that. But you know what you know. You're as prepared as you can be. Hopefully, you've done a good job of getting prepared. But I mean, we're just having a conversation. I think oral argument done well is we're just exchanging ideas, and you're helping the three lawyers who are honored to serve as justices come to the right decision, whatever that is. But you can do it. You can do it. If I can do it, I mean, anybody can do it. So as you can see, I'm not good at the shut up part. Yeah, I'm working on that.
I don't have a timer running today, so you're good. You can talk as long as you need. But no, okay. Well, I appreciate it, both of you. Thank you once again. The DAYL appreciates it, and I'm sure the audience got plenty of good tips from you all today about having to appear before you all. And I can confirm it is a little less intimidating than I thought it would be. So they'll make it easy on you if you let them. But again, everybody, appreciate your time. We're going to leave today. The last thing I'll say is we'll do one more. We have a third part of this series in August. We're going to be joined by a Supreme Court justice and one of her clerks and learn a little bit more about the Supreme Court level of practice. But again, Justice Nowell, Justice Peterson, thank you for your time and have a great day, everybody.
Thank you.
Thanks a lot.
Bye, everyone.